What if a seller of a subject to transaction dies after the close of escrow? So in a previous episode, I asked, well, what if the seller dies prior to the close of escrow? Now the question is, what if a seller on a subject to transaction dies after the close of escrow? So after the close of escrow means that title has transferred from the name of the seller to the buyer, and the buyer then owns the property subject to the existing loans for which the seller is the borrower, and the seller has now passed away. So what does that mean? Does the lender just automatically call the loans? Does the seller's estate have a right to, rescind the transaction? What happens if a seller dies after escrow closes? As to the buyer and the seller and their relationship, basically it depends on how the contract or the transaction was structured. But if it was structured as a subject to closing with a wrap, which is what I recommend and how I recommend closing the transactions, which means that the buyer has given the seller a promissory note, and that promissory note is secured by a deed of trust or mortgage against the property, basically making the seller the lender. And that promissory note states what the buyer's obligations are as to the property and as to the existing loans. Basically, it says the buyer will, the promissory note says that the buyer will pay the monthly payments to the lenders and will satisfy all obligations of the existing loans. So it's generally what we call a performance note, which it obligates the buyer to perform in a certain way. And basically that's to make the existing lender whole, and to write the monthly payments to the existing lender, to make sure to keep the property insured, to do everything that they're required to do as a borrower under the property. Well, that promissory note is a tangible personal property. So a promissory note is basically an obligation by one party to pay another. And so the party that holds it, we call them the holder, the party that holds the promissory note, so the lender, has that promissory note, and that promissory note is an asset. And so when the seller passes away, that is an asset of the seller. And then that asset goes in and becomes part of the estate, and then will be distributed according to either a will or a trust, or if neither of those exists, the state where the seller passed away, their intestate succession laws, the note will be passed on to the seller's heirs. And then the heirs of the seller can enforce the note if the buyer isn't paying. Basically, they make sure that the buyer is doing what they've agreed to do and obligated themselves to do at the time of closing the transaction. As to the existing lender, really nothing changes. The buyer is already making the loan payments. Generally, the purchase contract or the subject to addendum is basically going to, the seller's going to covenant and warranty that, they're not going to do anything to in any way, impact the buyer's rights to the property. They're not going to go and try to, have the lender invoke the due on sale clause. They're going to basically cooperate so that the buyer can perform and not interfere with the buyer's performance under the contract. Well, that clause would be binding upon the seller's heirs. So they can't then call up the lender and say, hey, the seller died, why don't you call the loan due or something like that. They're not supposed to do that. That would be a breach of the documents that they signed. Instead, basically the process goes on as normal. The transaction goes on as normal. The buyer writes their payments to the lender or to the servicing agent if one's been appointed, and the servicing agent then writes the checks to satisfy the loan obligations. If the subject to transaction was done with a promissory note secured by a deed of trust or mortgage, then that promissory note is distributed by the individual with authority to manage the affairs of the deceased seller's estate, and it's given to the deceased seller's heirs or beneficiaries, and then they have a right to enforce it, but only if the buyer breaches, only if the buyer stops paying. Nothing changes. Basically, the transaction has already been fulfilled. It's closed. and everyone just goes on and continues to do what they're doing. The only difference is now, instead of the seller, who is now deceased, holding the note, the seller's heirs or beneficiaries of their estate will hold the note to make sure that the buyer is performing.